Deborah Kessler stood in my driveway with a clipboard in one hand and a stopwatch app open on her phone, and she smiled when she told me my dog had until Friday to disappear, or she'd have animal control drag him off my own property. She had no idea what was clipped to his vest. She had no idea what federal law actually said about that dog. And in 11 days, her own HOA's attorney would call me personally to apologize. But 3 weeks earlier, I didn't know any of that was coming either. My name's Adam Reyes. I'm 34, I fix commercial HVAC systems for a living, and 18 months ago I moved into a quiet, tree-lined subdivision called Willow Creek Estates because it looked like the kind of place where nothing ever happened. Beige houses, trimmed lawns. A community pool nobody used before 10 a.m., the kind of neighborhood where the biggest scandal is whose trash can is still at the curb on a Wednesday. I didn't move there by accident. 4 years ago, I was in an accident on I-40 that ended with 2 herniated discs, chronic nerve pain, and panic attacks that came out of nowhere, grocery stores, parking garages, once in the middle of a Home Depot checkout line. My doctor and a licensed therapist worked with me for over a year before they signed off on what came next. A psychiatric service dog named Tank, not an emotional support animal, not a pet. A trained service animal, task-trained to interrupt panic attacks, brace me when my legs give out from nerve pain, and retrieve dropped items when I can't bend. He wears a vest. He has paperwork. He's 105 pounds of golden retriever who has never once barked at a stranger in the 2 years I've had him. My neighbors knew Tank before they knew my last name. He walked the same loop every morning at 6:15, past the Hendersons' rose bushes, around the cul-de-sac, back past the community pool, and people waved at him the way you wave at a mail carrier you've grown fond of. Kids asked if they could pet him. I always said the same thing: he's working, but thank you for asking first. That's the part people don't understand about a service dog. He's not a pet I get to enjoy. He's medical equipment that happens to breathe and wag its tail. I told my HOA about Tank the week I signed the closing paperwork. I emailed the property management company a copy of his handler letter from my physician. I got a 2-line reply, noted, "Welcome to Willow Creek." That was it. For 14 months, nobody said a word about my dog. Then, in March, Willow Creek Estates elected a new HOA board president. Her name was Deborah Kessler, and within 3 weeks of taking office, she had already sent violation notices for a mailbox painted the wrong shade of black, a garden gnome she called an eyesore, and a basketball hoop that had apparently been positioned 4 inches too close to the sidewalk. Some people whispered she'd run for president just to have something to control. I didn't think much of it. I figured she'd never have a reason to knock on my door. I was wrong. It was a Tuesday morning, the second week of April, when I found the first envelope taped to my front door. Bright pink paper, HOA letterhead. The subject line read, "Unauthorized animal, immediate compliance required." I stood on my porch in my socks, reading it twice because I genuinely thought it was a mistake. It was. The letter claimed that Willow Creek Estates enforced a strict no pets over 40 pounds policy, that my dog was in direct violation of Section 7(3) of the community bylaws, and that I had 10 days to permanently remove the animal from the premises or face a daily fine of $50, escalating to legal action if unresolved. I called the HOA office that same afternoon. A woman named Priya answered, sounding tired before I'd even said a word. I explained calmly that Tank wasn't a pet. He was a documented service animal, and under federal fair housing law, HOAs and landlords are legally required to make reasonable accommodations for service and assistance animals, regardless of any breed or weight restrictions in their bylaws. I told her I had the documentation on file already, sent 14 months earlier. "I'll flag it for Deborah," she said. "I'm sure it's just a form letter mix-up." It wasn't a mix-up. 5 days later, a second letter showed up, same pink paper, same threat. Except this time, at the bottom in Deborah's own handwriting, someone had added a note: "No documentation on file. Compliance required by Friday or fine begins." That was strange because I had the email receipt sitting in my inbox, timestamped 14 months prior, confirming they'd received it. Either Deborah hadn't checked, or she had and decided the rules didn't apply to her. I called Priya back and asked her directly to check the file herself while I stayed on the line. I heard her clicking through folders for almost a full minute. "It's here," she finally said, sounding confused. "It's been here since last year, so why does the letter say it is?" There was a long pause before she answered. "I don't know, that note wasn't added by me." I forwarded her the original email chain, documentation attached again, direct and polite, no accusations. I asked her to confirm receipt and close the matter. She never replied to the email. Instead, 4 days later, she showed up at my house in person. It was a Saturday, just after 9 in the morning. I was in the driveway loading tools into my truck for a side job when a white SUV with a HOA board parking permit pulled up across the street. Deborah got out mid-50s, sharp blazer even on a weekend, sunglasses pushed up into perfectly styled hair and walked straight toward me with a clipboard. "Mr. Reyes," she said, like she was reading it off a form. "I need that dog removed from the property by end of day Friday." I told her again that Tank was a service animal protected under the Fair Housing Act and that HOAs don't get to override federal disability law with a bylaw about pet weight. She didn't blink. "This is a private community," she said. "We have our own rules. If you wanted a big dog, you should have bought a house somewhere else." "He's not a pet," I said. "He's a medical necessity." "There's a difference, and the law makes that difference for you whether you agree with it or not." "I've heard that excuse before," she said. "It's not an excuse, it's federal law." I asked her directly if she was refusing a documented reasonable accommodation request. "I'm not refusing anything," she said. "I'm enforcing our bylaws. You have until Friday." Then she turned, got back in her SUV, and drove off, leaving me standing in my driveway holding a torque wrench, watching a 105-pound service dog sit calmly by my front door, completely unaware he'd just become the center of a federal housing dispute. I went inside and did something Deborah clearly hadn't expected me to do. I started keeping records. I photographed every letter with a timestamp. I saved every email. I pulled Tank's official task training documentation, his handler letter from my physician. And critically, I looked up something Deborah either didn't know or didn't care about. Under the Fair Housing Act enforced by HUD, a housing provider, including an HOA, cannot deny, restrict, or charge fees for a legitimate service or assistance animal based on breed weight. Or a no pets policy, and doing so knowingly can expose the association to real financial liability, not just embarrassment. That Thursday was the HOA's monthly open meeting, held in the clubhouse just off the pool deck. I almost didn't go. I went anyway, Tank at my side, and sat in the third row while Deborah ran through landscaping budgets and pool maintenance schedules like nothing was wrong. When public comment opened, I stood up. "I'd like the board to confirm on the record whether my service dog's documentation is on file," I said. Deborah's jaw tightened. "That's not an agenda item tonight, Mr. Reyes. It became one the day you taped a fine threat to my door." A few neighbors turned in their seats. Someone near the back murmured something I couldn't quite make out. Deborah glanced at the other board members, then back at me. "We'll follow up with you individually," she said, already moving to the next agenda item. I sat back down. Tank rested his head on my foot, completely unbothered by the 20 pairs of eyes now aimed in our direction. I'd made my point in front of witnesses. Whether Deborah cared was about to become very clear. Friday came, no fine posted. I assumed naively that meant she'd backed off. She hadn't. The following Monday, I opened my mailbox to find a certified letter, the kind you have to sign for, informing me that the HOA board had voted 3-1 to impose a $50 per day fine effective immediately, retroactive to the original compliance date. 9 days. $450. And the letter warned that if the unauthorized animal wasn't removed within 2 more weeks, the HOA would pursue a lien against my property. A lien over a service dog with a folder of documentation sitting in their own office. I sat at my kitchen table that night with Tank's head resting on my knee, and I made a decision. I wasn't going to argue with Deborah Kessler anymore. I was going to go over her head entirely. The next morning, I called a fair housing attorney I found through my state's Department of Human Rights website, a woman named Carla Whitfield who specialized in disability discrimination and HOA disputes. I explained everything: the timeline, the ignored documentation, the threats, the retroactive fine, the lien warning. Carla went quiet for a second, then said something I'll never forget. "They didn't just make a mistake," she said. "They created a paper trail of a federal housing violation and they mailed it to you themselves." I asked her what that actually meant for me practically. Was I supposed to sue, move, just keep paying fines until someone with more authority than Priya decided to care? "None of that," Carla said. "You're going to make it very easy for them to fix this correctly and very expensive for them if they don't." She told me 2 things needed to happen immediately. First, I needed to file a formal written accommodation request, again, this time sent directly to the HOA's registered property management company and their legal counsel, by certified mail, with a copy of Tank's documentation and a direct citation to the Fair Housing Act. Second, she was going to send a letter of her own on law firm letterhead informing the HOA board that continued enforcement against a documented service animal could constitute unlawful disability discrimination, and that HUD complaints in these cases routinely result in fines starting at several $1,000s. sometimes far more for repeat or willful violations. I sent my letter Thursday morning. Carla sent hers Thursday afternoon. Friday, nothing happened. I checked my phone every hour out of habit, half expecting another pink envelope, half expecting silence. I got silence, which somehow felt worse. Saturday at 8:45 in the morning, my phone rang. It was Deborah. It was Willow Creek Estates Property Management Company, and the man on the phone didn't sound like someone reading violation policy off a form. He sounded like someone who'd just gotten chewed out by a lawyer. "Mr. Reyes," he said, "I'm calling to inform you the fine has been suspended pending review and to apologize for the communication breakdown on our end." Communication breakdown, that was the phrase they landed on. I asked him directly whether the board had actually reviewed my original documentation sent 14 months earlier, or whether this review was only happening now because an attorney had gotten involved. There was a pause, a long one. "I can't speak to internal board communications," he said. Which in property management language meant yes. I told him that wasn't good enough. A suspended fine wasn't a resolution, it was a pause button, and I wanted this closed permanently, in writing, with a formal acknowledgement that Tank's accommodation had been valid since the day I moved in. He said he'd escalate it to the board's legal counsel and get back to me by Monday. I hung up and sat with that for a minute. A suspended fine, a vague apology, and a promise to get back to me, none of it was a real answer, and I wasn't going to let this drag into another month of pink envelopes and half explanations. Carla had already told me what came next if Monday didn't bring something concrete, a formal HUD complaint filed with everything I'd documented from day one. Monday came. And so did Deborah, one more time, uninvited, standing at the edge of my driveway instead of walking up it this time. No clipboard, no sunglasses pushed into her hair. She looked like someone who'd spent the weekend on the phone with people who outranked her. "I heard from the attorney," she said, arms crossed. "This is apparently more complicated than I thought." I told her it wasn't complicated at all. It was federal law, and it had been federal law the entire time she'd been taping pink letters to my door. "The board didn't realize the documentation was already on file," she said, which was, at best, a half-truth, and we both knew it. I asked her one question, just one. "Would you have backed off if I hadn't gotten a lawyer involved?" She didn't answer that one. She just said the fine would be permanently removed, the file would be closed, and the board would be issuing updated guidance on service animal accommodations to avoid future confusion. 3 days later, Carla called me with the part I hadn't expected. The HOA's own attorney, not Deborah, not the property manager, but outside legal counsel hired by the board itself, had reached out directly. He confirmed in writing that the association's prior enforcement action had been improper under the Fair Housing Act, that all fines were void, that no lien would ever be filed, and that the board had been formally advised in a closed session that further action against my accommodation could expose Willow Creek Estates to a HUD complaint and real financial penalties. He also said something else. He said the board president, Deborah, had been specifically instructed by counsel to issue a written apology to me directly separate from the association's formal letter. Because her personal note on that second pink letter, no documentation on file, had been factually false, and could be used as evidence of willful, not accidental discrimination if this ever escalated further. 2 days after that, an envelope showed up in my mailbox. White this time, not pink, handwritten. 4 lines from Deborah admitting she'd acted without confirming the file, apologizing for the stress it caused, and confirming in writing that Tank's accommodation was permanent and would never be challenged again. I won't pretend that letter fixed everything. It didn't erase 3 weeks of stress or the $450 in fines I had to fight to get voided, or the sight of a 105-pound service dog sitting quietly through every single one of those confrontations. Completely unaware he was the reason a woman with a clipboard had just been forced to eat every word she'd said in my driveway. But it did something else. It confirmed on paper, in writing from the HOA's own lawyer, that I had been right from the very first pink letter, and that no bylaw, no board vote, and no HOA president with a stopwatch and a superiority complex gets to override federal disability law just because she doesn't feel like reading the documentation sitting in her own office. I think about that Saturday morning a lot, the one where I stood in my driveway holding a torque wrench, watching her drive off, having no idea whether any of this would actually go my way. I didn't have a law degree. I didn't have connections at the HOA. What I had was a folder of dates, an email with a timestamp, and a dog who never once flinched no matter how loud the conversation got around him. Sometimes that's genuinely all it takes. Not confidence, Not confrontation, just documentation and the willingness to not back down when someone with a clipboard tells you the rules don't apply to you. 6 months later, Tank still walks that neighborhood every single morning, same route, same time, past the same house where a certain HOA president now waves, a little too enthusiastically, every time she sees him coming. She's never sent another pink letter to anyone on our street since, as far as I've heard. A few neighbors told me the board quietly rewrote Section 7.3 that summer to explicitly reference fair housing accommodations, word for word, straight out of the federal guidance Carla had cited in her letter. Funny how fast policy gets updated once a lawyer's name is attached to the complaint file. If you've ever had an HOA, a landlord, or anyone in a position of borrowed authority try to tell you that federal law doesn't apply to them, you already know how satisfying it feels when the paperwork finally does the talking for you. If this story hit home, tell me in the comments if you've ever had to go to war with an HOA over something that should have never been a fight in the first place. And if you want more stories like this one, you already know what to do before you go.